What was the single business non-technical hurdle you had to overcome to get those first crucial customers to trust a digital signature?
So, to answer that question, Jen, I have to frame it. Meaning, as you say, we were competing against the fax machine and a FedEx envelope. Those were our two primary competitions, our competitors, and the established behavior was well understood. So we had to radically shift how people behaved. And the fundamental premise, or not premise, the fundamental um, lever that we could pull on was that in 1998, 99, the federal government had passed a law called the eSign Act. And the eSign Act said that you could nationally recognize an electronic signature as a binding legal element. So that was the foundational piece that had to be in place for us to start the company. However, nobody had ever adjudicated a case that was legally signed by an electronic signature. So my biggest hurdle in the earliest days was getting the chief legal officer of any company of substance to agree to use it, because from their perspective, they knew they were playing it safe. All the lawyers were like, hey, you're asking us basically to bet our business on this technology, because if our sales contracts get challenged in court and they don't hold up, we don't really have a leg to stand on. So yeah, sorry, we'll pass for now. And we got that again and again and again. And so in a pure moment of entrepreneurial necessity, I did something that most people probably might not have considered. I went out and I hired a judge, a jury, and a prosecuting and defense attorney. And I found a case of a document, an insurance document that was being tried for whether or not it was an actual signature. And I adapted the case to an electronic signature. And then I paid for them to run the entire trial to completion in the hopes that what we would achieve was a ruling in favor. And that would be the basis that I could then send to a chief legal officer and say, see, it will hold up if it goes to court. What I actually did or accomplished was so far better than that I couldn't even have imagined, because not only did the judge rule in favor of the electronic signature, he went on to write an opinion paper after the fact. And the opinion paper said, I have tried as a judge, dozens of these kinds of cases, and never before have I seen so much overwhelming evidence to support the concept of a signature. And it was so much better than a handwriting analyst coming in to decide whether this was the person's legal signature in ink or not, whether you could decide whether the fax was legitimate or not, or somebody had applied a signature after the fact. He said, this was a slam dunk. Okay, so now having that judgment in hand, I could go to the chief legal officers of any company and say, look, this actually will hold up. You're safe coming in the water. And that was a huge, one of our several huge unlocks at that time.